Forensic science then stems from the word forensis. In Roman times, that means public forum. Senators and others would get together for a chance to debate each other on the issues. Notice debate is not a scientific thing. So science is really the newcomer to this whole field of forensic science. Just to be clear on terminology, we have criminalistics and criminology. Mr. Banks already explained to you the idea of hard science versus soft science. So the soft science is criminology, and we will be focused on the hard science, normally known as criminalistics. Across the nation, crime labs have basic services. They include the physical sciences, which means physics, chemistry, and geology. There's always a biology unit. We have firearms and ballistics, document analysis, and photographic examination. Crime labs can be government run at the federal or local level, and they can also be run by private consulting businesses. Here are a few examples of various forensic fields. Some of these have been around for a long time. Others are in their infancy, which means some of their evidence doesn't quite support the claims they make, and we'll investigate some of those throughout the year. The beginnings of forensic science go back all the way to 700 CE. Notice here in 1149, King Richard introduced the idea of what was to become eventually the coroner. Notice this is a political position. In fact, back then, this individual had no scientific or medical expertise. So let's get into the science. There are a number of principles or assumptions we make in order to investigate a crime scene. One is the Locard principle. Edmond Locard, a French professor in the 1900s, established that whenever two objects come in contact with each other, there is always a transfer of material. That's right. As soon as you leave this room, you leave something behind, and you take something from this room with you. Kind of weird, but that's true. That's a principle that we use all the time in forensic science. These federal rules are where science and the law actually come together. So there's a lot of evidence that we can identify, but to be admitted in court, it must be probative and material. Notice the use of the word prove here. Science and the law do not speak the same language, and that we will see later on may be problematic in our understanding of the truth. There are two case laws that are important to establish science in the courts. First, we have the Frye Standard. Notice the wording here. Generally accepted by the relevant scientific community. This was a ruling passed in 1923. A lot of convictions were made before that time that was not based on really good sound science. Notice who gets to decide what is science. The jury decides. And in case you didn't know it, the jury is made up of the people, and the people are not so scientifically literate. So there's a problem there with this Frye Standard. In 1993 then, the Daubert ruling came about. Notice here, the Daubert ruling is a huge step towards having science in the court of law. All of the things we've talked about in terms of science and engineering practices are part of this Daubert ruling. Unfortunately, it just doesn't go far enough. In this case, the judge gets to decide what is scientific and what is not scientific. Most judges are not well versed in the ideas of science. They don't have a really solid science background. So the judge then decides, based only on your credentials and your background experience, whether or not you are an expert witness and whether or not your opinion is significant. Has nothing to do with the actual science you conducted on the evidence. So we have two types of evidence here, direct and circumstantial. Direct, or what we call testimonial evidence from those that may have witnessed the crime or have some probative information to help the case. Video recordings can be also direct, but circumstantial is the physical evidence we've talked about before, and the physical evidence is much more reliable. So physical evidence could be fingerprints, blood, or hairs. This physical evidence or biological evidence is also known as trace evidence. We know from our mental modeling article that physical evidence is more reliable, but it may even be problematic if science is not done well. We can see here in this description of physical evidence that there's a problem then in the idea of science and the law. Science affirms their model rather than proving beyond a reasonable doubt. So to say that physical evidence can prove that a crime has been committed is a misnomer. We can generate a great deal of information from the physical evidence. Much of what forensic scientists do is to compare the unknown to the exemplar, and the exemplar is what is known. We can also discuss evidence in terms of its characteristics. So we have individual characteristics or class characteristics. Individual means I can tie this piece of evidence to a particular person or a single source. Class just means it comes from a particular group or a number of people. So for example, we have these fibers. This, I cannot tell what fiber or what garment it came from, but the glass, even though it's broken into pieces, if I fit those pieces together, I can identify it as coming from an individual piece of evidence. I'm going to finish this video by showing you these next three slides. They indicate then what forensic investigations are able to focus on and able to do. And that wraps it up. Make sure you note make.